give people a thank you. We're going to record this session, and we will just allow people a little bit longer to join. There have definitely been some challenges around getting people where they need to be, and I want to make sure that everyone who wants to be here will be able to participate. While we're doing that, I'm going to try to upload the program. So just give me one moment, or I should say this, the PowerPoint slides. Okay, it's a big file, but it's getting up there. All right, so those are our presentation slides in a PDF format. If you flip through them, you'll see there's a lot of material for an hour, so we may not get to everything, but you'll have at least the material at hand. And of course, if you have questions or want to reach back out to us, please do so. So why don't we go ahead and get started here. I'm going to share my slides and we can do our introduction. Actually, let's do our introductions and then share slides. So I'm going to start us off. My name is Darren Mitchell. I am a consultant to the National Council of Juvenile and Family Court Judges, but I'm also proudly a consultant to the CCDV, and I've helped with this overall symposium, and I've worked with my colleagues in Bexar County for quite some time now. I'm a lawyer, and I've been working as a technical assistance provider and trainer on issues related to family court decision-making, where there's domestic violence and firearms, civil protection orders, and related issues. Now it's my 23rd year doing so, and I'm very pleased to be working again with two of my favorite judges from around the country. We'll start with one who's traveling the farthest through the ether, and that's Judge Madden. Would you say hello, please?
Good morning or afternoon, everybody. I guess we're in the afternoon. My name is Mary Madden, and I am a family court referee in Hennepin County, which is the 4th Judicial District in the state of Minnesota. I have been on the bench for about 14 years, and I practiced family law exclusively for about 20 years before that. So that is my background. No criminal, all family. I've worked with both Darren and Judge Alvarez, so I am happy to see everybody here.
Judge Madden. Judge Alvarez, would you say hi, please?
Yes, absolutely. Hi, everyone. I'm Mary Lou Alvarez. I have the pleasure and the privilege of serving as your civil district court judge here in Bexar County. This is my first term, so I'm a relatively young judge, but prior to taking the bench, I spent about 15 years litigating cases. The majority of that time was at legal aid representing victims of domestic violence in divorce, protective order, and custody litigation.
Terrific. Can you all see the first slide? Okay, and it's showing up as a presentation. Excellent. All right, we are going to dive right in, and the topic for this session is child-related relief. So access and possession and other related relief in your civil protective orders. And we're really going to dive into, we're not bringing you information from, we're not talking to folks from all around the country. We're really trying to dive into Bexar County and what your challenges and opportunities are. And you'll see that this presentation is partially sponsored by the Department of Justice Office on Violence Against Women, and nothing that we say represents the office's views or opinions. It really just represents our own. Our learning objectives for today. We are hoping that by the end of today's session, you'll understand and be able to explain why including child-related relief in civil protection orders is critical for the protection of vulnerable people, children, parents who are subject to abuse, by establishing clear parameters around especially possession and access of children. You'll be able to recognize the significant obstacles to inclusion of that kind of relief in your civil protection orders in Bexar County, and then how to implement or at least start thinking about effective and feasible strategies to overcome those challenges. My slides all of a sudden have darkened the bottom text. I have no idea why. It did not do that before. I apologize for that. To summarize what we're going to focus on today, we're going to talk about why. Why should possession and access be addressed in why should it be addressed in civil protection orders? Why shouldn't we wait for a domestic relations, a family law court with a longer term decision-making process in place to decide possession and access? Then we'll look at, well, I think we'll convince you why it should be. Why is it not always addressed in cases in Bexar County? What are the barriers and challenges? And then finally, we're going to help you think about how to overcome those barriers and challenges. We'd love for you to type in, chat in your name, professional role, your organization. It really helps us to understand who is with us today. And we can also try to shape the presentation to meet your all needs. So if folks wouldn't mind using the chat and just letting us know who's here with us, we'd really appreciate it. You can do that as we move forward with the presentation. Thank you so much. What we're talking about, and I'm going to, when I have a break here, I'm going to put this in chat as well so you can download it. A lot of what we're talking about are a series of guiding principles and practices that were developed by the National Council of Juvenile and Family Court Judges in collaboration with judges, court personnel, attorneys, advocates, attorneys for respondents, as around a set of principles and strategies for courts to address possession and access within child civil protection orders. So there's a lot more information in this guide than we can convey today. We want you to know that it's there and available as a resource. And turn it over to Judge Alvarez.
All right, thank you. So I just wanted to remind everyone that Texas protective orders and in our code, there are actually specific provisions that allow the protective order to provide for, and these are quotes right out of the statute, possession of and access to a child of a party if the person receiving possession of or access to the child is a parent of the child, and then the payment of support for a party or for a child of a party if the person required to make the payment has an obligation to support the other party or the child, again, either a parent or a spouse. And so I think a lot of times these provisions get overlooked, and it's an opportunity to get relief and to set boundaries and parameters to a situation that's otherwise not just chaotic, but violent. And so I really hope that people try to take a look at that. And then there's another provision right under that. So this is 3, 4, and then there's 5, which will allow the protective order to award to a party the use and possession of specified property that is community property or jointly owned or leased property. Again, very important provisions in our Title IV protective order statutes that would give an opportunity to get some parameters and to give some relief to people who are also seeking protection from violence.
So one of the things we need to do, you've got the statute that enables you to provide relief, but why is that available? Why did Texas include that? So if you could take a few minutes and just type in your answer to that question, why are custody and other child-related relief provisions available as part of the Texas statute?
Why did your legislature decide that this was an important thing to do at this stage in a process through a kind of a proceeding, a fast proceeding? And some of you may have even been involved in lobbying the legislature for that to be included in the statute. What are the benefits? I think chat is enabled. There we go.
To protect children. Yep, that's absolutely right. Other reasons to help protect children and help them have access during custody disagreements.
Why not just say as a blanket matter, if you have a protective order against you and you've committed abuse, that you shouldn't have access to your children, period, until there's a chance to make a decision in a longer term custody court. Preventive nature to keep them with a parent. That's a good response to that. Have you all worked in situations in which it's actually more protective, potentially, for there to be some careful, prescribed access to both parents while this is all going on in the court? And that may be part of the reason that the legislature would include the ability to get, some access, even if you've committed the abuse or have initially been found to have committed the abuse.
So custody relief within the context of protective orders, meaning you want to designate which parent the child should be, which is typically the victim parent, is necessary for safety in a number of cases. We've got to consider both the short-term and the long-term effects on children of exposure to domestic violence. There are routinely abusers' use of children as tools of abuse to maintain contact with the victim and to retain power and control. If it's not designated in an order who has custody, there can the kids get caught in the middle and can really be damaged as a result of being pawns. Orders that are silent just create lots of circumstances that can be dangerous. There's an increased risk associated with victims separating from their abusers. I see in my own court where there are 14 of us who look at civil protective orders, we have very different opinions, it is appearing, on what constitutes immediate and present danger in order to get an emergency order. And so I think for us, we need to have further discussions about the increased risk associated with victims separating from their abusers. We've also got the shared purpose of providing safety for kids and well-being. If victims do not believe that their children will be safe and that they will be in a position to protect them, it becomes an obstacle, and victims will not seek relief from the courts. Designating custody certainly decreases trauma for children. There is research out there that shows children's trauma symptoms will be lowest when the perpetrators are out of the house or they are removed from the perpetrator. There's also considerations of safety for the larger community, neighbors, classmates, workplaces, so that there are not incidents of violence in those places where children may be. It also, addressing custody in civil protective orders also confirms and affirms the victim's parental authority and provides support for the victim's parental role, which may have been undermined during the course of the relationship and the dynamics of domestic violence and family violence that they've experienced. It also sets boundaries for safe contact of children with the abuser if appropriate. And that can be details like days, times of exchanges, when exchanges are going to occur, under what circumstances, curbside exchanges, third-party exchanges, supervised visitation center. You need to talk about phone and video contact, and limiting communication with the victim parent and the perpetrator, for lack of a better word.
So there's, in addition to the research by Finkelhor that Judge Madden mentioned, another big piece, and Dr. Edelson talked about it this morning when he talked about children's resilience. There are factors that certainly make it more likely that children who've been exposed to domestic violence in the home will not suffer lifelong consequences. And some of those factors include continued care by a safe primary caretaker, that there be stability both at home, within the school they're attending, and within their broader community. There are other adults, coaches, teachers, etc., who can support the child, that they overall live in a violence-free environment, and also that they have access to some counseling where needed. And a well-crafted civil protective order can do that and more if the information is provided to the court and the judge decides it is necessary. And that's why we're having this conversation. We want to increase resilience for children, despite what they've been exposed to, which we've heard about all morning long. And I want to just point a couple of quick things out from the chat. One is someone mentioned to provide protection, but help parents navigate access without needing to file the corresponding family case. Not everyone can hire a lawyer, sets parameters, and absolutely, and I'm sure you all know many situations in which the parties just can't go to family court for that long-term case. And so this sets important parameters during a critical time, which is one of the reasons we are promoting it. Of course, if folks do go to family court, and we'll talk about this a little later, what's decided at the protective order stage can influence that ultimate decision, but that court gets to hear more evidence over a longer period of time to decide ultimately what's in the long-term best interest of the children. So I appreciate you saying that. And then someone else asked about the sharing of the presentation. If you scroll up in the chat, and it may be that you came in too late, but if you scroll up in the chat, there is, I did not. I just sent it to the captioner. So I'm gonna have to do it again. I apologize. The captioner has the presentation. I will do that again. All right. A lot of compelling reasons for why we should be doing this. The question now for us, and is in Bexar County, or if you're coming, I know people are coming from other places as well. Why is child custody access and possession issues not being addressed in Bexar County in civil protection orders? What are some of the reasons you've seen where folks may need this kind of relief as part of their protective order and they're just not getting it?
And I'm really curious for us to share, for those of us here in Bexar County that are representing applicants in protective order and respondents in protective order litigation, why you believe it's not being done.
And if you prefer to not chat and unmute yourself, we can do that. Raise your hand, we'll unmute you. Not enough evidence does not rise to the level of abuse per the Texas code. So in instances, this sounds like it's part of it is around not getting a protective order in the first place. Is that right? Or are you talking specifically, is there something about children and possession and access that you're referring to there? Anyone else see cases in which this should be addressed and it's not?
What about your, I don't know what your calendars or your dockets look like, but what about time? Is always a huge factor. There's never enough time. Is that something that is struggled with?
And someone's mentioning, I think, a practice that is really kind of Texas specific and Bexar County specific, which is it's a sticky subject for district attorneys or ADAs who do not practice family law. It's easier to punt it, not file at all, or non-suit when access becomes an issue, to be blunt. And we appreciate your bluntness in speaking up. This is not, I mean, it's not like pointing fingers necessarily. This is a difficult, like you said, it's a sticky subject for folks in an office that's focused on criminal practice. And so maybe that's part of what we're seeing. We certainly see that in other contexts where folks were folks with in the criminal system are needing to address things around children or families, and it can be more difficult in those contexts.
I have a question to add here is, from your anecdotal perspective, how often is there not child-related relief specifically about custody and visitation in civil protective orders? Like none of the time, half the time, all of the time? Anything that would give us a sense would be helpful. The comment, long distance calls with the abuser are not considered hazardous since the death threats cannot be acted upon. You are absolutely correct, because a car or an airplane or whatever can get you from one point to another in a heartbeat.
Judge Alvarez, do you have any thoughts around the prevalence of orders issued without child-related relief?
So I think from what I've seen, both in litigation and on the bench, I think there's this expectation that another office is going to handle it, right? And I guess to answer Judge Madden's question, I think for a great majority of the low-income applicants who are seeking relief from public sources, right, whether it be TRALA or the DA's office or pro bono lawyer through San Antonio Bar Association, more times than not, there is not the counterpart private litigation, custody litigation, divorce or SAPS being filed simultaneously. Usually it's considered a two-step is what I've seen, right? We get the protective order first and then we'll deal with whatever comes next, or get the protective order first and we'll give you the 1-800 number to the OAG's office so you can stand in their queue to get custody orders. So I think that's something that has continued. And I think with the COVID, making the queues longer all around, that's become a more dangerous approach to the extent that with the boundaries and with the parameters comes safety, right? With knowing when the possession and access is going to take place, there's a predictability, there's an ease to the chaos and consequently, hopefully, an ease to the violence. And so, so I think that's something that we should be considering, right, as we move forward.
I see somebody put in the chat that almost never. And so regardless of what your role is in the system, whether you're an attorney arguing to the court or your judicial officer, we certainly hope that this seminar will help give you some arguments to make to the court, as well as some considerations the court can make how to improve this particular form of relief.
Yeah, so I'm just going to summarize a couple of the things that we hear, especially Judge Madden and I do these kinds of trainings all over the country. And some of the things that we hear about reasons for not addressing issues around children and protection orders is a lack of understanding about the impact of abuse on children and also on parents, both the parent who is the target of the abuse and what it means for that parent's parenting, but also how parents who are using violence or using coercive control, engaging in coercive control, how they are as parents, because a lot of their parenting reflects that exercise of power and control and coercive control. There's lack of time to do it. You barely have time to make findings on domestic violence, let alone what's necessary around what's in the best interest of the child in this emergency period is a challenge. Many times it's not sought, and that's part of what we're hearing here. At least some of the protection order petitions are not asking for child-related relief, and sometimes folks related to that, then it's not asked because folks are self-represented and they don't understand what's available, how to request it, and how to support those requests. So the evidence a court will find convincing in including child-related relief, possession, and access in the order. And then there's some philosophical issues. There's the idea that this is not the right venue to be doing this. The right venue is the family court with its ability to have fuller litigation, or that people are making these things up. They're making up claims of abuse. They're misusing the system to get a leg up in a custody case. So we'll address all of these challenges, and like right now. And our goal with the rest of the time is to start thinking about how do we overcome some of these challenges, knowing that it's critical to address issues around children in protective orders. So I want to just start off by telling us and reminding us all that this is not about pointing fingers, and it's not about pointing fingers at the judges for not doing it. It's not about pointing fingers at the DA's office or the private bar or respondents, folks who are representing respondents. It really requires a community-wide approach and understanding. And where we've seen change in this area, and Judge Madden will be able to talk about that through what she's seen in Hennepin County, Minneapolis, where she sits, it really takes multiple agencies, multiple disciplines. It's all of our responsibilities. And we're going to talk a little bit about this toward the end. but we definitely want to dive into some of those challenges that we talked about. So I'm going to turn it over to Judge Madden to get us started. You know, my computer's doing a weird thing here, showing blank slides. There we go.
So I think, yeah, we can go back to, I think going back to the whose responsibility is it? We look at ourselves, many people on here are judicial officers. And so is it the court's responsibility to make all of this happen and ensure that there's more consistency in the courts incorporating the relief offered in the statute to parties? Is it court staff and court-based programs? Is it court administration's responsibility? If you've got a self-help center, is it self-help center's responsibility? If you have guardians ad litem, is it the responsibility of the guardians ad litem to address these issues? There are community programs, there are shelters, there are domestic violence programming programs. Is it their responsibility? We've got other justice system stakeholders. We've got supervised parenting time programs. We've got attorneys, definitely. We've got therapists, and we've got law enforcement. And so it's really everyone's responsibility. We've all got competing interests. And so it cannot just be one person's responsibility. And we all often don't know what the other entities are doing. And a critical part of everyone's responsibility for the judicial officers on this in this session is judicial leadership. There is something to be said, if you build it, they will come. And if a judicial officer takes a lead role in trying to coordinate better responses, that has a significant impact. And that can be done without the concerns of the court can't participate because the court is neutral and unbiased. But the court also has an interest in improving the administration of and access to justice. So that role, I think, is really important. It's also important to collaborate. In Hennepin County, over the last several years, we've had participated in numerous projects where we had management teams and committees and subcommittees with 25 to 30 various disciplines and backgrounds to address these issues. Accountability in that as part of this process is important. So you have that core team that meets regularly. Set yourself goals and objectives. Have regular meetings. And then important in a conclusion of this is evaluate what you're doing. Some of this is you're trying it out for the first time. Some of it you're trying from another community and it ends up not working in your community. So stop and evaluate and listen to others and other stakeholders, what's working and what isn't. It's all of it is, some of it is an experiment. Some of it is tried and true or true and tried practices, and others is trying to figure out what works for your community.
Thank you, Judge Madden. And please do chat in any questions you have, raise your hand. We're happy to try to respond to any concerns or questions. So the first challenge that we mentioned was around the lack of understanding about how abuse affects children and parenting by both of the parents. And you heard already from Dr. Edelson this morning about how abuse affects children. Very clear picture. We don't have to spend more time on that. There's lots of research to show the short and long-term effects, including through the ACEs study, the Adverse Childhood Exposures or Experiences study, that these can last through the lifespan of the person. Wanted to just point out a couple of things. We're going to talk a little bit later about the SAFER approach, and there are a couple of sessions in this track of the symposium that are addressing SAFER. But the folks at the Battered Women's Justice Project who developed that approach, which I'll give more details about in just a few minutes, have developed some tools around what parenting by an abuser parent looks like, especially one who was a coercively controlling abuser. And we don't have to go into details, and we can get you a copy of this sheet, but there are harms to the child, physical security and well-being, but also emotional, developmental, cognitive development. The economic stability of the child is often threatened, and the kids are pulled in as tools of the intimate partner violence by people who use this form of abuse. So it's important to understand that a protective order can begin to stop this from happening to children. In addition, there are other things that abused parents do. They don't acknowledge the damage or attempt to repair the damage caused by their abuse. And actually, when we start to see them acknowledge and repair, that's a time that you all, the judges and others, can start to think about, okay, maybe access should be increased because we're seeing a recognition of responsibility and an attempt to repair the damage, which we don't see in many individuals for quite some time, if at all. People who engage in this kind of abuse can't distinguish their own needs, the child's need, from their own. It's really about themselves. They interfere with the other parent's ability to parent the child. That is a very common tool of coercively controlling abusers. They undermine the parenting in sneaky ways and less sneaky ways, through the food that they allow the child to eat that is not really part of what the other parent wants for the health. So always taking them out for ice cream, saying, Mom won't let you do this, or Dad won't let you do this, but I'm going to let you do it. Ignoring important medical issues and things like that. And of course, the relentless harassment, the domestic terrorism that Evan Stark sometimes calls coercive control, all obviously affect children, and folks need to look for it and understand it in making decisions, including in protective orders. Another thing, a second challenge that we talked about is the lack of time to address these issues. And I'm going to turn it over to Judge Alvarez to talk a little bit about that from the Bexar County perspective.
And this is important because, our Bexar County presiding court system, our virtue and our vice kind of thing, this actually minimizes this challenge because the protective order cases, whether they're set at the 10 o'clock docket or the 9 o'clock docket, you're all in the same pool with the divorce and the SAPSER cases. So you're all being heard by our civil district court judges who are hearing and presiding over all of these cases. So appreciate that and incorporate those provisions and seeking relief on those provisions in the time announcement for the protective order case. It's not an either or. And I really hope that this presentation starts to get people thinking about that our Texas legislature and our family code actually anticipated that possession and access and support provisions would be incorporated in the same order that was being sought to obtain protection from violence. And I hope we don't lose sight of that. And so incorporate those provisions, questions about those provisions, your outline on what evidence needs to be marshaled to get orders on those provisions into the time announcement for the protective order case. And I appreciate and understand that the protective order case itself, just with the violence, the finding of family violence in the past and the likelihood that violence will occur again in the future, that in and of itself may be a 3-hour announcement. And maybe with the other stuff, you're at a 4-hour announcement or more. But that's what we're here for. And if that order with those provisions covered would save 2 or 3 more enforcement hearings or calls to the police on orders being violated, then perhaps the judicial economy is gained in the long run. And so, so I encourage all of you to think about that and to, anyway, I'll stop talking. Go ahead, Darren, I'm sorry.
Oh, that's great. And Judge Madden, do you have any thoughts around the issues around lack of time?
It's a real issue. Some of the things that we have done to address that is develop some form orders that are extremely comprehensive and that are easy to just delete provisions that don't apply in any given case. It takes a lot less time to do that than to write in every time when you're trying to provide the relief that's available. So we include provisions, a variety of provisions regarding custody, parenting time, support, et cetera. So that is something that has been really useful for us.
Thank you.
I just wanted to address the person who wrote in the chat about schools and the protective orders. I definitely agree. Schools is a big issue. Schools, I know, are concerned about liability and other issues, as well as safety of children. And I assume that your statutes allow you to address not only restrictions from going to the victim parents' residence, but also children's schools. In Minnesota, they have the right to have access to information from the schools, but you can specifically put in the orders that the parent against whom the order is issued is prevented from going to the school.
If the children are included as protected persons from the protective order. And that's something that we that we should have our litigators consider. If you are going to kind of take the road without all of the barriers and just seek protection for the adult, even when they share children, know that that's going to cause confusion at the schools, at the doctor's offices, etc. So be mindful of that, and again, invest the time up front so perhaps things become clearer as we move forward. And I did want to remind everyone, we do have the Family Violence Prevention Program here. It's a relatively new office for the civil district courts and our children's courts. So please know that that's a resource, and if there's forms that need to be found, or for our community partners that are here from school districts, if there's concerns that you don't have the orders, please reach out.
I have one question about that. If it's not on behalf of a child, but temporary custody is granted to the petitioner, can you restrict the respondents from going to schools?
So the legislature in Texas was pretty deliberate that what can be addressed in the protective order is possession and access, not custody. And so they kind of just fell short on how broad that protective order can give relief with regards to parent-child relationship issues. And so that is part of some of the confusion, but it's possession and access. And you could arguably, I think, consider possession and access at the school as part of the provisions that are included in the protective order.
Okay.
Thank you for explaining that. Okay, so we're going to move on to the next challenge we wanted to talk about. And I see there was another chat about getting resource information. And if you could chat in which resources you're talking about, happy to share them. I did chat in that guide I showed earlier from the National Council, and I also chatted in the slides today. So if you scroll up in the chat, you should be able to see them. So the next one is that it's not being requested. This kind of relief is not being requested by the parties, and related to also the fact that many folks are self-represented. So we wanted to talk a little bit about some ideas here. And one is the opportunity to provide resources to the community and to litigants about what is available as part of a protective order. And so we've worked with communities that have developed brochures that emphasize what kind of relief around your kids you can ask for from the court. And that it's not, in Texas, you would say it's not about long-term custody, it's about possession and access. And here's what that means. And here's the basis that the court uses to make that decision. But also things like the availability of services that you can seek. And I know that your court, I know Judge Alvarez has really been at the forefront of understanding what resources are available in the community, including for safe access by the parent who is the respondent on a protective order. So supervised visitation safe exchange services where there's a professional entity, trained entity that that regulates the exchange of children during visits. The availability of therapy and other therapeutic supports that are available both for parents and children. It's helpful to publicize that to the folks who are coming into this process so they can request it. So the judges hear those kinds of requests. I think your court, thanks to Judge Alvarez's work and the FVPP, has really, made some strides in understanding what's available in the community and, connecting people in cases who would benefit. And I know there's an effort also for the people who are using abuse, the respondents, to get services that they need. And so this is something that we cannot promote enough, which is there are lots of community services. You'll see there was a follow-up email to you all who have registered for the symposium that included, in addition to the program, a list of resources that were developed last year in Bexar County that can provide some of these kinds of resources. And actually the question around family violence resources, take a look at your email. You'll have a confirmation from the CCDV for the symposium that includes a very long resource guide around what's available in the county.
Thank you. And I have included the website for the Family Violence Prevention Program off of our Civil District Courts page for Bexar County. So please bookmark that page, reach out to those folks, and don't forget our Domestic Relations Office. So they also have form orders when you're thinking about supervised visitation and considering supervised visitation at Kids Share or, oh my gosh, the Guardian House. So please be mindful that these forms are here at our administrative offices and they're there to be shared.
I'll just quickly add other ideas that you may want to think about. If any of you are working for a service provider who develops materials, informational materials for victims, to talk about how judges make decisions about possession and access so that they know what to bring to court. And of course, if you're an attorney, you can do this, provide the legal advice. If you are not an attorney, you can only provide legal information that this kind of relief is available. But you can also explain how the protective order process relates to other things that the family may be involved in, right? There may be a corresponding criminal matter. There may be a child protection matter that's going on simultaneously. And folks, families do not understand how they relate to each other, and they assume that the judges, if it's not the same judge, know what's happening in each of those cases. And so that's something that's really important for litigants, especially victims, to understand about the systems and processes that they're involved in. I saw that there's a question in the chat around when a victim applies for a protective order, they want to include children, but they have civil custody orders for the other parent to have visitation. I might have missed the answer. I'm not quite sure what you're at. I don't know if our other panelists know what the question is, but if you wouldn't mind explaining, you can unmute yourself and explain if you'd like what you're seeking. You mean there's a separate family, or there's already a civil custody order that was issued against the parent, and now, but that there was a civil protective order issued, but the person it was issued for is actually the abusive parent, and now the other parent's coming in. I'm not sure what the situation you're talking about is. Would like to try to help you with that.
There's another answer in the chat. I'm sorry.
No, go ahead.
That indicates the terms of the protective order limiting access would trump the prior custody order, but only as long as the protective order is in place. And that was going to be my question, is perhaps there's some confusion on that. That's the way it works in Minnesota as well.
Yeah. And you know what? I'm going to skip right to a slide where we lay out Texas law on that real quickly, which I think may be helpful, because I think it's an important point. I know Judge Alvarez is in a position to try to explain it.
Right. And so, and thank you for the question. And there is expectation and anticipation that the folks who are in protective order litigation may also be in divorce and custody litigation, or there may be final orders already rendered in a divorce or final orders already rendered in a custody issue or a modification on a custody issue. That needs to be, that should be brought to the court hearing the protective order. So if those terms need to be modified in consideration of the protective order being granted, that can be taken into account. But know that the protective order litigation moves forward. It can be transferred over to the divorce, or it can be transferred into the custody, or it can be brought at the same time. But the ongoing divorce and custody litigation does not preclude anyone from seeking protection in the civil protection order statutes. But again, to the extent that we are all considering ways to improve the decision-making, to improve the evidence that is marshaled before the court, so the protective order, the judge who is hearing the protective order has the best information to render the most appropriate orders, please bring that to the attention to the trial court. Don't assume that the court that's hearing the protective order case knows what the custody provisions were in your custody litigation a year prior or 6 months prior, because you may be losing an opportunity to make more effective possession and access orders that would meet the family's needs at the time that the judge is making those decisions. And those are the statutes. 85.061 again precludes the court from dismissing the protective order application because there's a divorce pending or a custody case pending. 85.062 indicates that the party can apply for the protective order in the divorce or custody case, but it's not required to. 85.063 indicates that the applicant can apply for a protective order even when the divorce and the custody orders have been rendered and issued, right? So you can't say, oh, well, she can't get a protective order, or he can't get a protective order because, you know, Judge so-and-so rendered the final decree 3 months ago, right? That's not what is permitted. And then 85.064 is that the civil protective order case can be transferred if that is in the interest of justice and if there's safety concerns for the parties or the witnesses.
Thank you, Judge Alvarez. I'm going to move us to a challenge, the fifth challenge we were talking about earlier, because it's particularly relevant to this conversation, which is the belief that this process, the civil protective order process, is not the right place to decide custody and visitation, and that it's inappropriate to use DA resources to prepare and litigate these possession and access issues as part of a protective order. So we wanted to take a minute and talk about that. And I can get started, and then I'd love for Judge Alvarez to weigh in from her perspective on the bench, and Judge Madden as well, of course. But the first thing is just kind of a reality check to all of this. And a couple of people have mentioned in the chat, what happens when you don't address access and possession issues as part of a protection order? Just think what might happen while the petitioner waits for another court process to proceed and for these issues to be addressed. And if Bexar County is anything like every single other county in the country, those cases are not swift. We designed the civil protection order system to provide immediate, critical, life-saving relief. And the legislatures around the country have included some pretty comprehensive relief for these orders, including the child access and possession issues that you have in Texas. So if you force someone to wait and they are subject to a continuing force of either physical abuse or coercive controlling conduct, which is always a pattern and which often escalates, at a time when you've now had someone ask for a protection order, indicate that they may be trying to get out of a relationship, and the danger, as the research has shown, this idea of separation abuse, is starting to peak. We are really not using the system for what it's meant to be. It is not the safest approach. It is okay, and many judicial officers who have been part of our work have said that in their practice, they know that it's okay to sometimes get things wrong and clear them up later, but to act on the side of safety at this critical juncture. So it's really important that we do so at this stage of the process. And we know, someone chatted in, folks face barriers of having to go to the family court for a long-term order. It may take a while for them to be able to do so. But I'd love to hear, Judge Alvarez, if you have any thoughts on this issue.
Well, I think in our community itself, we've seen that the denial of possession and access provisions actually may lead to a more dangerous situation, either physically or with the coercive abuse, right? The ability to continue to pester either through in-laws or friends or aligned interested parties, someone who has a protective order increases if there aren't parameters of when the possession and access should occur. Because then it's just this constant barrage of, well, what about this? 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 And I don't think that's what we intend. I don't think, obviously, that's not what I intend with the protective orders. I don't intend to open an invitation of additional harassment for the applicant. And I don't think that it creates the most predictable situation among parents when they're trying to get access or trying to understand what the parameters look like in the post-separation, two household, multiple household kind of existence as they move forward from being a nuclear family to being a separated family.
Madden, did you have anything to add on this issue?
I don't think so at this point. I think you guys covered it well. Thanks.
Thank you. So let's talk about this. I'm going to turn it over to you now, Judge Madden.
Okay, we're going to talk about this belief that continues to be pervasive both within among us as judicial officers and outside of the courts, which is the belief that parties are trying to game the courts. In other words, filing a protective order to get a leg up in the custody matter, and that the courts and petitions for protective orders are filled with false allegations. But does it happen? Yes, it does. But I think we need to consider the research that's out there, which specifically does not support the perception that there are widespread false allegations. I won't go through citing each research study here, but I think it's important to point out that there is no empirical or qualitative evidence to substantiate allegations that women, who are most often the petitioners and victims in protective orders, were making strategic use of those orders to prejudice fathers' positions in custody cases. And some additional research here indicating that there is not actual support for that perception is that in the studies that have been done, only 12% of child sex abuse allegations were deemed intentionally fabricated. In fact, and I think this is a really important statistic, custodial mothers and children were the least likely to fabricate false claims of child sexual abuse at 14%, but non-custodial fathers were the most likely to fabricate those false claims at 43%. So I think it's really important to keep that in mind as we go through these cases. And I think, and I'm hoping that your experience as judicial officers would be similar to what has been found in these studies, that as you're reading petitions for protective orders and you're handling those cases. Darren?
I wanted to just note a couple of comments. There's some really good comments, and I appreciate the interaction. So definitely take a look at the chat. And someone mentioned that custody as opposed to possession and access is included in protection order. So that court doesn't retain continuing jurisdiction over the kids. And I guess that's a matter of Texas law. So thank you for that. It can be different in different places, and so under the statute that addresses interstate custody, a decision around possession and access can constitute a custody order in some circumstances. So it's a complicated legal issue, but we appreciate you talking about the Texas side of things. And then this idea that if you have a protection order that doesn't address access by the respondent, if the respondent does want that access, or sometimes just to continue to harass or exercise power and control, will go back to court. And it forces the parties back to court, and the batterer in many instances is the person who's able to actually come back in with counsel, which of course can be a real leg up. And so a very important point and reason why addressing possession and access as part of protection orders can be really important for folks. I mean, that doesn't always stop people from relitigating what happened around possession and access, but you can pretty much guarantee it if you don't in some families. We have about 7 minutes left. I want to do a preview of coming attractions around the SAFER model, because I want folks to go to those sessions, which are coming up later this afternoon. I'm also going to chat in some information before I forget around the next session and the ones that follow. So I've just chatted in information about the KSAT roundtable, which will be streamed on KSAT around mass shootings and domestic violence. It's going to be an excellent conversation. But I wanted to do my little preview of coming attractions and talk about SAFER. SAFER is a model that was developed by the Battered Women's Justice Project. It was developed as a systematic approach to decision-making around children in domestic violence cases for any professional who has to make some sort of decision, whether you're an attorney making an argument, a guardian ad litem making a recommendation to the court, or a judicial officer who's deciding what's in the best interest of the children. This is a way of systematically assessing domestic violence in the case. And it's a 4-step process. In the civil protection order context, you don't have to screen typically because it's in the order. So as a judge, you wouldn't have to screen for domestic violence. You'd be assessing what's going on in the case. But if you're an attorney, a family law attorney, or an advocate working with a victim, you may want to do some screen, or a therapist, you're an evaluator, or someone doing alternative dispute resolution. You should be screening and asking, is abuse an issue here that needs further investigation? The second step is to say, what is going on? What is the nature and context of any intimate partner violence, IPV, intimate partner violence in the family? That means who is doing what to whom? That means, is the child directly exposed to the abuse? Are they witnessing it? Are they witnessing the aftermath? Are they being told about it? Is the abuse physical? Is it physical and non-physical? Is it coercive control? What's happening in this family? And then you don't figure out that there's abuse and you immediately respond, whether through a written order, if you're a judge, or a recommendation. Instead, you ask yourself, why does that abuse matter? What are the impact or the effects of that abuse on the children and parenting, as I mentioned earlier? So in doing so, you're asking for the child, are there cognitive delays? Are there behavioral issues that may be due to the abuse? Are they themselves, have they been physically injured? Are they suffering? Has their well-being suffered? Are they bedwetting, trouble sleeping, things like that? For the victim parent, what does that person's parenting look like? Is it being undermined by the other parent? Once you understand the nature, context, and the effects, then you can respond and decide what can be done about that abuse. And the idea of this model is that your response is not cookie cutter. You don't say, in all cases involving domestic violence, I'm going to say no access for the abusive parent. Or I'm always going to allow access, but it'll be supervised. Or I'll just allow access because the child didn't witness the abuse. Instead, you're going to respond to exactly what you're learning about what's happening in that family. And so in some instances, visitation may be safe if it's constrained and done in a supervised setting and things like that. So you really want to try to be responsive to what's happening in the family. And this approach forces you to do that. I'm just going to show you a couple of tools real quickly. These are the kinds of tools that BWJP has developed, and they will talk about in the 2 sessions that follow around figuring out what's going on, nature and context, and orange, what's the effect. And you can see the kinds of questions that are asked. And this is actually a checklist for practitioners or for judges. Some judges use this in their family court hearings to keep track of all those things, ultimately to make a recommendation or a decision about what should be done, which is this, what can the response be? And you may, hopefully you can read it. I can read it on my screen. It is a large set of potential options that are not all available as part of protective orders in Texas, but some of them are creative responses to what's happening in the family, and certainly family courts can include a lot of these in their orders. So that's kind of an overview of the SAFER approach, which the BWJP folks later this afternoon will be walking you through in the context of these kinds of cases. Keep it in mind if you're a practitioner who's making arguments on behalf of victims, or you're an advocate who's working with victims. There's a whole suite of tools. If you go to bwjp.org, Better Women's Justice Project.org, bwjp.org, and look up SAFER, you'll get the full set of tools in one place. So we only have a couple of minutes. I will turn it back over to my co-presenters to see if they have any last words you want to share.
I guess the only last words I would share is that the SAFER tool that Darren just talked about is, I can't say enough good about it. It is it's a sophisticated, innovative, yet simple tool. Application of the tool can be more complicated, but it's a no assumptions approach. It's not a one size fits all, as Darren commented on. You look at these 3 elements, the nature and context, and the effects of the abuse on the children and the parenting by both parents. So when you're examining a specific case, it is, you can tailor a remedy for that family as opposed to that cookie cutter approach. So if you can make that go, the worksheets are phenomenal. If you don't go, they're online. And I'll let Judge Alvarez close us out.
Right. Thank you. Thank you. And thank you all for being here. I guess the key takeaway is the protective order case, the litigation on that remedy, it's not supposed to be easy. It's not supposed to be routine. It's not supposed to be, just pushing paper through. It requires a lot of effort. It requires going out of your comfort zone. The applicants and the respondents are obviously out of their comfort zone, but it gives us all an opportunity, not just the bench, but the litigators, the officers of the court. It gives us an opportunity to put as much context before the court to make the best decisions possible. And the Texas legislature has given us tools. They have given us an invitation to really address the needs of the applicant, especially when the applicant and the respondent share children together. And so I just encourage all of you to rethink how it is that a protective order case is presented to the bench so the best order can be rendered and the chaos and the violence can be minimized.
Thank you all so much for spending time with us. Thank you to Judge Madden and Judge Alvarez. We obviously could have gone into detail and spoken for a couple hours, 3 hours. We do all day trainings. Please do reach out. I put in my email address. I can connect you with folks with expertise around these topics. Please, everyone, go to KSAT and watch. It's going to be a fabulous session. And then after that, you'll have options. Again, there are 3 tracks and you have options. And if you stay on the legal track, you'll hear more about SAFER. So thank you. Take care, everyone.
Thanks, everyone. Enjoy the rest of the seminar.